Welcome, class. Today we are going to look into a major restriction on the exclusive monopoly conferred by copyright. The whole proprietarian conception of copyright, coming as it does with its philosophy of property essentialism, considers the copyright owner to be the sole authority and with absolute discretion, limited by nothing, to deal with the property as he pleases. Compulsory licenses challenge this philosophy. In a sense, compulsory licenses replace the ex post determination of the value of the copyrighted work either by an independent adjudicator or by an administrative machinery put in force by the government, and they substitute this ex post determination with an ex ante determination by a similar body of the value of this particular work and the royalty payable for exploitation of the work by a third party. So the third party, before making use of the work in question, is aware of what the rate of royalties are, and all he needs to do is to apply for a license and pay the royalty as determined prior to this. Of course, this may not be the only structure through which compulsory license works. But in any case, the important aspect here is the very socialization of copyright. And when using the word socialization, of course, one has to be open to the kind of loaded connotations that it may carry. Yet, one can choose to use that word for the simple reason that a private property right is, through the mechanism of a compulsory license, sought to be made a social right. Instead of an absolute property right, which is governed by property rules wherein if you step into my property, I will sue you, to a more liability oriented regime where you can step in, but you just need to pay the rates of royalties as fixed by the license. And the license itself is, in some sense, coerced through the machinery of the state. One can clearly say that there is an attempt to make a private property right into a social right. Now, the way the social right operates, again, apart from the whole ex post and ex ante determination, could be to go with carving out licenses at special rates, carving out licenses for special class of licensees, or even both. So various different combinations are used by the law as it currently stands in order to provide for such compulsory licenses in respect of different kinds of works. Before we get into a close examination of the Indian law that governs compulsory licenses under the Copyright Act, it is imperative to take a look at what the international conventions say on the permissibility of a compulsory license. How is it that the law looks at these licenses? Are these exceptions or these facets of the very right in question? If they are exceptions, under what situations and conditions can such exceptions be provided? For starters, the Berne Convention provides for a general exception in Article 9. This is the three-step test contained in Article 9, wherein as long as the legitimate interests of the right holder are not unfairly prejudiced and an exception does not conflict with the normal exploitation of the work, member states can in certain special cases provide for exceptions on the exclusivity of the right contained or provided for by copyright law. This is of course a very general exception. Apart from this general exception, the appendix to the Berne Convention by way of Articles 2 and 3 does indeed provide for compulsory licenses, and India is also a signatory to the appendix in addition to the main treaty. Article 2 of the appendix explicitly permits member countries to replace the exclusive right of translation in respect of published works with a system of non-exclusive and non-transferable licenses. These licenses are granted in situations where the translation is not published or authorized by the owner of the right of translation in a language in general use in the opting member country within a period of 3 years from the date of first publication of the work in question. So the very idea here is that the owner of the work is given an option to either translate or not translate, and there is a 3-year window. If the translation does not happen within the 3-year period in a language that is commonly used in the member country, then there is no longer a requirement to go to the owner and give him that property right in respect of the translation. Rather, the law says that there is a compulsory license that you will obtain from the state, and you can make use of that as a translator who wishes to translate that particular work. All you need to do is pay the rates of royalty as fixed. Similarly, Article 3 provides for situations where the published work is not made available at prices reasonable on a comparable scale for similar works. In such cases too, a compulsory license can be granted in replacement of the exclusive reproduction right, and the licensee can then make these works available at prices which are reasonable in that particular member country. Similarly, the Universal Copyright Convention also provides for licenses in respect of translation of published works and reproduction of works that are unavailable in the country upon payment of just compensation. So what we see here is a regime that is very similar in its working to the principle of eminent domain that we see in the context of actual real property, where the philosophy is to gauge whether there is a public interest, and in the presence of a public interest to appropriate property but upon payment of just compensation. But the fact that just compensation is mentioned here as a restriction on the power to grant or effect the grant of a compulsory license should not make us in a causally reflexive way to assume that copyright is private property but in the intellectual property space. There are nuances to copyright law that make it different from pure property rights in the physical space, including the fact that it is non-rivalrous and the fact that there are many other variables and dimensions to copyright, such as the fact that expressive content can be used to further free speech and expression. Having said that, the structure of compulsory licenses is indeed very similar to what we see in the real property space, and therefore a lot of the discussion from the level of policy making to judicial interpretation of the provision has bordered around usage of metaphors in the real property law space. This is something that we will see soon enough. To sum up the above discussion, it is pretty evident from the international conventions that India is signatory to, including the Geneva Phonograms Convention, that compulsory licenses are not unique to the Indian model of copyright law and protection. There are provisions that authorize compulsory licenses that exist on the ground, and the Indian law makes use of some of them and their structure, and in some situations it does indeed deviate, but eventually follows a similar philosophy. Whenever there is a public interest involved, the law slowly moves its focus or emphasis from a proprietarian understanding of copyright to a more regulatory understanding, and compulsory licenses and statutory licenses are a strong source of bringing in regulation to the exclusive or otherwise exclusive property right that copyright is largely envisaged as being, or at least perceived as being. With this, we can move to the provisions in the Indian law that deal with compulsory and statutory licenses, the preconditions and the governing situations wherein such licenses can be granted, and other matters incidental therewith.